God bless America. Hello, everybody. I am the Talk Radio Protege. This is the Protege program. Thank you so much for joining me. This is going to be a hefty video, to say the least. And I want to start by showing you the big headline that was all over Drudge Report almost all day on June 21st. Supremes kill free web, internet sales tax. Online shoppers face reckoning. Now, that struck me as very interesting. So, of course, I clicked on the link and I read the article. High Court. Online shoppers can be forced to pay sales tax. States will be able to force more people to pay sales tax when they make online purchases under a Supreme Court decision Thursday that will leave shoppers with lighter wallets but is a big financial win for states. Consumers can expect to see sales tax charged on more online purchases, likely over the next year and potentially before the Christmas shopping season, as states and retailers react to the court's decision, said one attorney involved in the case. Now, let's think through this together because I'm still formulating my understanding of the issues and where I fall on them. So, think about it this way. You're shopping online and you purchase a product from Amazon, and Amazon has no store in your state. Now, this is an interesting topic, and it's going to take some time for us to think through it together, I think. So, if Amazon had a store in your state, you could go to their store and buy their product, and you would pay your state's sales taxes. Now, what if Amazon had a store not in your state, but in the next state over, and you went to the next state, and you went to the Amazon store, and you purchased a product? You're now paying for that state's sales taxes because you traveled to that store and purchased that product. Now, one broad overarching question that I have is, how does taxation without representation play into this? How does taxation without representation play into this? Because that's an issue, one of the issues that we fought a war over. The Revolutionary War was in large part started because the colonies were being taxed by the British government without having representation in the British government. And that was one thing that the founders cited as a reason to rebel against that government. So, how does that play into shopping? If you go to another state and purchase a product, is it right for you to pay the sales taxes because you didn't have a chance to vote on that state's sales tax? Well, you could think of it this way. You could think of it as you going to that state for the sake of shopping, for the sake of purchasing a product, is consent by you to pay those sales taxes. Consent that those sales taxes are right and just. Now, it's one thing to say that if you're shopping at a big chain store. If you go to Walmart in South Dakota and you live in Florida, there's Walmarts in Florida. If you wanted to shop at a Walmart that charged sales taxes like the Walmart in Florida shop does, you would shop at the one in Florida. You wouldn't go to South Dakota. But what if South Dakota has a store that is not in Florida? Well, you have to consent to go to that store and purchase their products. Therefore, you have to consent to abide by South Dakota's sales tax laws. Right? Am I making sense? Is the act of shopping adequate consent to the taxes such that you waive your right to representation in a system that is going to tax you? Now think of it in terms of online shopping. you can shop at Amazon. You probably don't have to go to an Amazon store to buy the product that you want to buy from Amazon. You can probably buy an Amazon product from your local Walmart. You can probably buy most Amazon products from a store in your state. So by shopping on Amazon, are you adequately consenting to the sales taxes of the state in which Amazon is located such that they can charge you sales tax? There is no debate that you have to go, that when you go to a state and shop at a place in that state, that you shouldn't pay their sales taxes. The debate is when you purchase a product online, should you have to pay for sales tax in a state whom you're not physically touching? That's the debate that's wrapped up in this case. Let's read a little bit more about this case from the Associated Press before we move on. The Supreme Court's 5-4 opinion Thursday overruled a pair of decades-old decisions that states said cost them billions of dollars in lost revenue annually. The decisions made it more difficult for states to collect sales tax on certain online purchases, and more than 40 states had asked the High Court for action. 5 states don't charge sales tax. The cases the court overturned said that if a business was shipping a customer's purchase to a state where the business didn't have a physical presence, such as a warehouse or office, the business didn't have to collect sales tax for the state. Customers were generally responsible for paying the sales tax to the state themselves if they weren't charged it, but most didn't realize they owed it, and few paid. Justice Anthony Kennedy wrote that the previous decisions were flawed, and we're going to read this. Is going to be part of the video today, so I'm going to skip over it for now. The ruling is a victory for big chains with a presence in many states since they usually collect sales tax on online purchases already. Now rivals will be charging sales tax where they hadn't before. That is to say that big chain stores that have presences in a lot of states are on a playing field of X difficulty, and related stores stores that might be almost exclusively online and have a presence only in one state, shipping to all of them, are on a different playing field. And this is raising the bar of difficulty, raising the bar of entry, you might say, into the online retail space, making it more difficult for smaller businesses to break into the scene. And the government, the legislature anyway, is usually more favorable to small businesses than big businesses. The federal government usually wants to see more small businesses develop than less. Big chains have been collecting sales tax nationwide because they typically have physical stores in whatever state of purchase is being shipped to. Amazon, with its network of warehouses, also collects a sales tax in every state that charges it, though third-party sellers who used the site didn't have to. Until now, many sellers that have a physical presence in only a single state or a few states have been able to avoid charging sales taxes when they ship to addresses outside those states. Online sellers that haven't been charging sales taxes on goods shipped to every state range from jewelry website Blue Nile to pet products site Chewy to clothing retailer LL Bean. Sellers that use eBay and Etsy, which provide platforms for smaller sellers, specifically individuals that are selling a few products occasionally, also haven't been collecting sales tax nationwide. Under the ruling Thursday, states can pass laws requiring out-of-state sellers to collect the state's sales tax from customers and send it to the state. More than a dozen states have already adopted laws like that ahead of the court's decision, according to state tax policy expert Joseph Crosby. I want to skip on down and read a couple of other paragraphs for you. The lineup of justices on each side of the case was unusual, with Roberts joining 3 more liberal justices, Ginsburg joining her more conservative colleagues. So it is an interesting flip in terms of who's voting where. So before we get into reading this thing, because it's 40 pages, you're probably going to want to have a dictionary open, the website, a physical dictionary, Google's dictionary. You're probably going to want to have something, because there's probably going to be some words in here that you don't understand. There is going to be words in here that I don't understand. I know that for a fact. And for some more insight, I'm going to be referencing this article from Tax Foundation, published in November 5th, 2007, Why the Quill Physical Presence Rule Shouldn't Go the Way of Personal Jurisdiction. This is also a very long article. It is very interesting, very informative. I would encourage you to go read it. The Tax Foundation is the nation's leading independent tax policy nonprofit since 1937. Our principled research, insightful analysis, and engaged experts have improved lives through smarter tax policy. For a further look into who the Tax Foundation is, here is their 2018 State Business Tax Climate Index, where they rate the top 10 best states in this year's tax index as number 1, Wyoming, number 2, South Dakota, number 3, Alaska, Florida, Nevada, Montana, New Hampshire, Utah, Indiana, Oregon. I'm pretty sure these are all red states. For further reference, their 10 lowest ranked states are Rhode Island, Louisiana, Maryland, Connecticut, Ohio, Minnesota, Vermont, California, New York, New Jersey. Off the top of my head, blue state, red state, blue state, blue state, purple state, blue state, blue state, blue state, blue state, blue state. So that's who the Tax Foundation is. That's the way that they think about taxes. So here we go. 40 pages. Supreme Court of the United States. South Dakota v. Wayfair Incorporated et al. What does this word mean? I'm going to have to look this word up. I would like to copy and paste it. Certiorari, a writ issuing from a superior court calling up the record of a proceeding in an inferior court for a review. Okay, I learned something new today. To the Supreme Court of South Dakota, this is where the court is being suit is being pursued from. Interesting that they rank number 2 in the 2018 State Business Climate Index, and now they're suing, and now they're about to blow. If you read this article, the Tax Foundation is in favor of the physical presence rule. So it's interesting that South Dakota would be rated so high when they're the ones involved in this suit. South Dakota, like many states, taxes the retail sales of goods and services in the state. Sellers are required to collect and remit the tax to the state, but if they do not, then in-state consumers are responsible for paying a use tax at the same rate. Under National Bellis Hess Incorporated v. Department of Revenue of Illinois and Quill Corporation v. North Dakota, South Dakota may not require a business that has no physical presence in the state to collect a sales tax. Consumer compliance rates are notoriously low, and it is estimated that Bellis Hess and Quill cause South Dakota to lose between $48 and $58 million annually. Concerned about the erosion of its sales tax base and corresponding loss of crucial funding for state and local services, the South Dakota legislature enacted a law requiring out-of-state sellers to collect and remit sales tax as if the seller had a physical presence in the state. The act covers only sellers that, on an annual basis, deliver more than $100,000 of goods or services to the state or engage in 200 or more separate transactions for the delivery of goods or services to the state. So according to this, South Dakota would not require an eBay seller who sells less than 200 times a year or $100,000 or less of goods to collect sales taxes. So that means for your folks that use eBay to get rid of stuff they don't want anymore, you're probably not going to be affected by this law or other laws like it. That remains to be seen, though. I wouldn't be surprised if eBay starts tacking on the sales tax, passing it on to this buyer of an eBay item, and then collecting that on your behalf as the seller. That's interesting. Respondents, top online retailers with no employees or real estate in South Dakota, each meet the Act's minimum sales or transactions requirement, but do not collect the state's sales tax. This word, respondents, must be the parties involved. Wayfair and others. Top online retailers and employees. South Dakota filed suit in state court seeking a declaration that the Act's requirements are valid and applicable to respondents, and an injunction requiring respondents to register for licenses to collect and remit the sales tax. Is this recording sound? Yes, it is. South Dakota filed suit in state court seeking a declaration that the Act's requirements are valid and applicable. Respondents sought summary judgment, arguing that the Act is unconstitutional. The trial court granted their motion. The state Supreme Court affirmed on the ground that Quill is controlling precedent. Held, because the physical presence rule of Quill is unsound and incorrect, Quill Corp, North Dakota, and National Bellis Hess Incorporated are overruled. So the Supreme Court, specifically the 5 justices that are ruling, said that Quill is unsound and incorrect. Now, if you... Okay. Quill... okay. Okay, here's where we're going to start getting into the legalese of this. An understanding of this court's Commerce Clause principles and their application to state taxes is instructive here. 2 primary principles mark the boundaries of a state's authority to regulate interstate commerce. State regulators may not discriminate against interstate commerce, and states may not impose undue burdens on interstate commerce. These principles guide the courts in adjudicating challenges to state laws under the Commerce Clause. They also animate Commerce Clause precedents addressing the validity of state taxes, which will be sustained so long as they, 1, apply to an activity with a substantial nexus with the taxing state, are fairly apportioned, do not discriminate against interstate commerce, and are fairly related to the services the state provides. And they reference some other cases. Before Complete Auto Inc., Transit Inc. versus Brady, the court held in Bellis Hess that a seller whose only connection with customers in the state is by common carrier or mail lacked the requisite minimum contacts with the state required by the Due Process Clause and the Commerce Clause, and that unless the retailer maintained a physical presence in the state lacked the power to require that retailer to collect a local tax. In Quill, the court overruled the due process holding, but not the Commerce Clause holding, grounding the physical presence rule in Complete Auto's requirement that a tax have a substantial nexus with the activity being taxed. The physical presence rule has long been criticized as giving out-of-state sellers an advantage. Each year it becomes further removed from the economic reality and results in significant revenue losses to the states. These critiques underscore that the rule, both as first formulated and as applied today, is an incorrect interpretation of the Commerce Clause. It might be useful, at this point, to go read the Commerce Clause. Okay. The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. That's it. That's all it says. The Congress shall have power to regulate commerce with foreign nations and among the several states. That's according to Wikipedia. Let's make sure we read the full thing. This is much longer. Where's the actual text? This isn't the actual text. Constitutional law. I don't think this is what I'm looking for. I'm looking for the actual text. This is Weck's Legal Dictionary. Where's the Commerce Clause? I want just the actual verbiage. It must be more than we just read in Wikipedia. Because if it's what we just read in Wikipedia, then the Supreme Court doesn't have jurisdiction. Article 1, Annotation 28. Where is annotation? What did it say? Section 3? Interstate among the Congress shall have the power to regulate commerce with foreign nations and among the several states. This directly gives Congress the power to regulate commerce between among the states. If my understanding of that verbiage is correct, then the Supreme Court doesn't have jurisdiction, neither do the states, insofar as taxing interstate commerce. Interesting. Quill is flawed on its own terms. First, the physical presence rule is not a necessary interpretation of complete auto's nexus requirement. That requirement is closely related, Bellis Hess, to the due process requirement that there be some definite link, some minimum connection between a state and the person, property, or transaction it seeks to tax. As Quill itself recognized, a business need not have a physical presence in a state to satisfy the demands of due process. When considering whether a state may levy a tax, due process and commerce clause standards, though not identical or that's a new word, coterminous. What does that mean? Coterminous. Having the same border or covering the same area, being the same in extent, coextensive in range or scope. Though not identical or having the same area, have significant parallels. When considering whether a state may levy a tax, due process and commerce clause standards, though not identical or having the same area, have significant parallels. The reasons given in Quill for rejecting the physical presence rule for due process purposes apply as well to the question whether physical presence is a requisite for an out-of-state seller's liability to remit sales taxes. Other aspects of the court's doctrine can better and more accurately address potential burdens on interstate commerce, whether or not Quill's physical presence rule is satisfied. Now, there's a lot of talk there about the physical presence rule. Let's talk about that for a moment. Physical presence rule. By overturning the physical presence rule, the court is saying that out-of-state businesses shall be subjected to in-state tax law. Does that make sense? See, states require businesses to collect sales taxes because you and I are, as was stated earlier in this document, notoriously bad at paying sales taxes directly to the Treasury. So the business has to collect the sales taxes. And if the business doesn't collect the sales taxes, I'm sure they're subjected to fines and other penalties. So let's think about this. Think about if there is no physical presence. A store sells goods in Oregon and is subject to the sales taxes of Oregon. And somebody from New York travels to Oregon and purchases a product from that store. Should the buyer pay New York sales taxes or Oregon sales taxes? What if the buyer wants Oregon to ship its product to New York? Does New York State have jurisdiction over that transaction? I would think the answer would be no. So, if the buyer now, what if the buyer makes a phone call to the business in Oregon and purchases the product over the phone? Does New York now have jurisdiction over the transaction? Because the only difference between a phone call order and an online order is you don't have to deal with a human. A human is not involved in an online order like they are in a phone call. So the only difference is human involvement. You can be a single state business and sell to all 50 states and have a website as long as no one orders a product online. I think I just cracked the code. Because we're talking about physical presence. The court just said that physical presence is no longer valid in taxation. The state can tax a business outside of its jurisdiction if that business is selling to customers inside the state on the internet. That's what the court just said. That's what we're talking about here. That means that if you travel to Oregon now from New York to purchase something, apparently physical presence doesn't matter. New York can now tax that transaction. If my understanding of this is correct, I'm very disappointed in the conservative justices on the Supreme Court. Maybe I don't understand this correctly. I think I do. Let me know if you think I've got this wrong. Second, Quill creates rather than resolves market distortions. In effect, it is a judicially created tax shelter for businesses that limit their physical presence in a state but sell their goods and services to the state's customers. Something that has become easier and more prevalent as technology has advanced. So, does that mean if a state picks up and moves, or if a business, let's say you're a one-shop business, you have one place of business, and you pick up and move, does that mean you're guilty of tax evasion? Because the court, through Kennedy, I think Kennedy authored the majority opinion, so I'm pretty sure he's mostly responsible for this syllabus. So is Kennedy saying that moving is tax evasion? Because it sounds like it to me from the way he's saying things. Let's keep reading. This is not getting any better in my opinion. The rule also produces an incentive to avoid physical presence in multiple states, affecting development that might be efficient or desirable. So is Kennedy saying that he knows better than businesses what's best for that business? See, you're doing really well as a business, but you're not expanding like you should be. Therefore, you need to be expanding. Folks, I'm not liking this so far. I've set my mind on reading all 40 pages of this, but I'm really anxious to get to the opinions and see what has been written there, to see why the conservative justices voted the way that, or ruled the way they did. Third, Quill imposes the sort of arbitrary formalistic distinction that the court's modern Commerce Clause precedents disavow in favor of a sensitive case-by-case analysis of purposes and effects. Is the court supposed to be making a sensitive case-by-case analysis of purposes and effects? I thought the court was supposed to be ruling on federal jurisdiction, whether or not a law was constitutional. It doesn't seem to be doing that. It doesn't seem to have made a ruling on South Dakota's law, but rather said, look, South Dakota's law would be constitutional if we would just overturn this earlier precedent. So we're going to do that. I don't know. It's not looking good. It treats economically identical actors differently for arbitrary reasons. It treats economically identical actors differently for arbitrary reasons. I know what the word arbitrary means, or I think I do. I'm just going to make sure. Subject to individual will or judgment without restriction, contingent solely upon one's discretion, decided by a judge or arbiter, rather than by law or statute, having unlimited power, controlled or unrestricted by law, despotic, tyrannical. They're probably talking about this definition of arbitrary, which is what I was thinking, that arbitrary basically means that there's no better reason than I decided it. So you might say, so for instance, if you're writing an equation, any old equation, say you want to make a math problem for a student to solve, every number is the very first number is totally arbitrary, because depending on how complex your equation could be, your first number is what's going to dictate how the rest of the numbers fall out. Now, for a really simple math question, like an arithmetic question, the question numbers are arbitrary. The answer number is not arbitrary. You can pick any two numbers to use in an arithmetic problem. It's totally arbitrary. It could be 1, it could be 1,000, it could be 576. It's arbitrary. But the answer is dependent upon the questions. That's what arbitrary means. So it treats economically identical actors differently for arbitrary reasons. Quill imposes an arbitrary formalistic distinction that the court's modern Commerce Clause precedents disavow in favor of a sensitive case-by-case analysis through the presence rule. Am I understanding this correctly? The presence rule is arbitrary, according to Justice Kennedy. He also thinks that these people are economically identical actors. A business located in Oklahoma is apparently economically identical to a similar business located in California. A business, let's say these two businesses have the same number of employees, earn the same revenue, sell the same number of widgets, make the exact same widget. The only difference is they're located in different states, and this is arbitrary, in Justice Kennedy's opinion. Well, it's not arbitrary for this reason. The two states have very different tax rules. So we need to identify that there is a difference between these two businesses that warrants the sales taxes being applied in a specific way. That's not arbitrary. For example, a business that maintains a few items of inventory in a small warehouse in a state is required to collect and remit a tax on all of its sales in the state, while a seller with a pervasive internet presence cannot be subject to the same tax for the sales of the same items. These are not economically identical. These are not economically identical entities. This is really annoying talking like this. These are not economically identical actors. One person is purposefully maintaining a supply of a product in a state. The other is choosing to not. Those are not, that is a distinct difference. What if this second seller, what if the seller with a pervasive internet presence is not selling a hard product, but is in fact selling a service? Are those economically identical actors? I don't think so. But apparently I don't know as much as Justice Kennedy. When the day-to-day functions of marketing and distribution in the modern economy are considered, it becomes evident that Quill's physical presence rule is artificial, not just at its edges, but in its entirety. Modern e-commerce does not align analytically with a test that relies on the sort of physical presence defined in Quill, and the court should not maintain a rule that ignores substantial virtual connections to the state. So, again, continue to liken this, because all we're talking about is shopping. That's all that's being talked about. Shopping for anything. Shopping for lawyers. That's all we're talking about. Continue to relate this back to physical shopping. And you've got my understanding of what Justice Kennedy is trying to say. Modern e-commerce does not align analytically with a test that relies on some sort of physical presence defined in Quill, and the court should not maintain a rule that ignores substantial virtual connections to the state. So now, a virtual connection is the same as a physical connection. You are virtually connected to the world, therefore, you are subjected to the world's rules and regulations. That sounds colonistic to me. This is again, I've said it over and over again, this is not looking good. I'm very anxious to get to the opinions and see what the conservative justices said about this. The physical presence rule of Bellis Hess and Quill is also an extraordinary imposition by the judiciary on states' authority to collect taxes and perform crucial public functions. So now we care about states' authority, whereas in a few earlier, I shouldn't yell, I'm in a hotel. Whereas in a few earlier court cases, we did not care about the state's authority. For instance, Roe versus Wade. Apparently we didn't care about the state's authority in Roe versus Wade. Apparently we didn't care about state's authority when it came to gay marriage either. All of a sudden we care about state's authority. 41 states, 2 territories in the district in D.C. have asked the court to reject Quill's test, helping respondents' customers evade a lawful tax unfairly, shifts an increased share of the taxes to those consumers who buy from competitors with a physical presence in the state. Helping respondents' customers evade a lawful tax unfairly shifts an increased share of the taxes to those consumers. So, this is delicious. I am loving and hating this at the same time. So if there's a Walmart in your state, and you move and continue to shop at Walmart in the new state, you're evading taxes. Respondents. Who are the respondents? The respondents, as defined by Justice Kennedy, are sellers with a substantial online presence. They have a very limited physical presence. They might even only have one store. They may not have a storefront. They may just have a warehouse somewhere. But they have a substantial online presence. And you buying from them out of state is tax evasion. That's the language that he's using right here. Evade a lawful tax. That sounds like tax evasion. Justice Kennedy just called you a criminal. Justice Kennedy just accused you of tax evasion because you refused to shop at a store that's going to charge you sales tax. Are you kidding me? This is disgusting to me right now. We're on page 3. It is essential to public confidence in the tax system that the court avoid creating inequitable exceptions. And it is also essential to the confidence placed in the court's Commerce Clause decisions. By giving some online retailers an arbitrary advantage over their competitors who collect state sales taxes, Quill's physical presence rule has limited states' ability to seek long-term prosperity and has prevented market participants from competing on an even playing field. So, some of this sounds like Kennedy is saying it's not fair to big businesses that small businesses with a big online presence can be as big as a big business without having a big physical presence. It sounds a lot like trying to undermine capitalism. Let's read on. Stare decisis. That sounds like something I need to have defined for me. The doctrine that rules or principles of law on which a court rested a previous decision are authoritative in all future cases in which the facts are substantially the same. So, precedent can no longer support the court's prohibition of a valid exercise of the state's sovereign power. The valid exercise of a state... Suddenly, I really want to yell right now. Suddenly, Justice Kennedy cares about the exercise of state sovereign power. Suddenly, Justice Kennedy cares about the exercise of state sovereign power. If it becomes apparent that the court's Commerce Clause decisions prohibit the states from exercising their lawful sovereign powers, the court should be vigilant in correcting the error. Apparently, Justice Kennedy thinks it's within a state's sovereign power to tax out-of-state shoppers. Oh boy. It is inconsistent with this court's proper role to ask Congress to address a false constitutional premise of this court's own creation. The Internet revolution has made Quill's original error all the more egregious and harmful. The Quill court did not have before it the present realities of the interstate marketplace, where the interstate's prevalence and power have changed the dynamics of the national economy. So because our modern shopping process has changed, we must now reinterpret the Constitution, essentially. This is Justice Kennedy talking about a living, breathing Constitution, which is not the case, but that's a subject for another time. And I can't tell by looking at OBS how long I've been recording, but I can already tell I'm going to run out of time well before we get through this document. So we're going to go ahead and skip. We were almost to the end of the syllabus. Let's go ahead and finish the syllabus before we skip. If it becomes apparent the court's Commerce Clause is inconsistent with the Internet revolution, the Quill court did not have before. The expansion of e-commerce has also increased the revenue shortfall faced by states seeking to collect their sales and use taxes, leading the South Dakota legislature to declare an emergency. Maybe it's not the revenue that's the problem. Maybe it's the spending. Did you think about that, South Dakota? The argument, moreover, that the physical presence rule is clear and easy to apply is unsound, as attempts to apply the physical presence rule to online retail sales have proved unworkable. It's only unworkable because there are online retailers that don't have a physical presence in the state. Because the physical presence rule as defined by Quill is no longer a clear or easily applicable standard, court says based on all this previous stuff that you've been spewing, arguments for reliance based on its clarity are misplaced. Precedent may accommodate legitimate reliance interests, but a business is in no position to found a constitutional right on the practical opportunities for tax avoidance. You keep saying tax avoidance. The only people that are avoiding taxation are the buyers here. Businesses do not pay taxes. They pass the taxes on to you. That's part of what this AP story said. Where did it say it? That will leave shoppers with lighter wallets. The sellers are not going to be paying these sales taxes. The shoppers are. Internet purchasing is going to drop like a rock. I'm starting to believe that Drudge was right when he says Supremes kill free web. Online shoppers face reckoning. Startups and small businesses may benefit from the physical presence rule, but here South Dakota affords small merchants a reasonable degree of protection. Oh, really? Why don't you tell me about that? Finally, other aspects of the court's Commerce Clause doctrine can protect against any undue burden on interstate commerce, taking into consideration the small businesses, startups, or others who engage in commerce across state lines. The potential for such issues to arise in some later case cannot justify retaining an artificial anachronistic rule that deprives states of vast revenues for major businesses. In the absence of Quill and Bellis Hess, the first prong of the complete auto test simply asks whether the tax applies to an activity with a substantial nexus within the taxing state. Here the nexus is clearly sufficient. The act applies only to sellers who engage in a significant quantity of business in the state, and respondents are large national companies that undoubtedly maintain an extensive virtual presence. Have you seen their extensive virtual presence? Have you seen their significant quantity of business in South Dakota? You have not defined a significant quantity of business. This is where Congress is supposed to do the work. When the Supreme Court starts throwing out things like significant quantity, things are going to get crappy really fast. Any remaining claims regarding the Commerce Clause's application in the absence of Quill Bellis may be addressed in the first instance on a remand. Kennedy delivered the opinion of the court. I hate this man's opinions. They are wordy, they are long, they are absurd to read. In which Thomas, Ginsburg, Alito, and Gorsuch joined. Thomas and Gorsuch filed concurring opinions. Roberts filed a dissenting opinion in which Breyer, Sotomayor, and Kagan joined. Why am I agreeing with the liberal justices? I'm skipping Justice Kennedy's opinion. This is going to be... This is... You see how long this is? You see how long this is? We started on page 4. We're now on page 15. And we're still on Justice Kennedy's opinion. This man is insane. I've heard rumors that he's going to retire soon. Please, Justice Kennedy, retire. This is absurd. Who is supposed to make heads or tails of all of this? We started on page 4. It is now page 29. 25 pages this man rambled. All right, here's Clarence Thomas's concurring opinion. Justice Byron White joined the majority opinion in Bellis Hess versus Department of Revenue. 25 years later, we had the opportunity to overrule Bellis Hess in Quill Corp versus North Dakota. Only Justice White voted to do so. Interesting. I should have joined his opinion. Today, I am slightly further removed from Quill than Justice White was removed from Bellis Hess, and like Justice White, a quarter-century of experience has convinced me that Bellis Hess and Quill can no longer be rationally justified. The same is true for this court's entire negative Commerce Clause jurisprudence. See this. Thomas dissenting. Although I adhered to that jurisprudence in Quill, it is never too late to surrender former views to a better considered position. I therefore join the court's opinion. That's all that he wrote. That's all that Justice Thomas wrote. That's all that Justice... I am very concerned at the moment. Justice Gorsuch concurring. Our dormant commerce cases usually prevent states from discriminating between in-state and out-of-state firms. Are you sure about that? Bellis Hess and Quill do just the opposite. For years, they have enforced a judicially created tax break for out-of-state internet and mail-order firms at the expense of in-state brick-and-mortar rivals. As Justice White recognized 26 years ago, judges have no authority to construct a discriminatory tax shelter like this. The court is right to correct the mistake, and I am pleased to join its opinion. My agreement with the court's discussion of the history of our dormant Commerce Clause jurisprudence, however, should not be mistaken for an agreement with all aspects of the doctrine. The Commerce Clause is found in Article 1 and authorizes Congress to regulate interstate commerce. Meanwhile, our dormant commerce cases suggest Article 3 courts may invalidate state laws that offend no congressional statute. Whether and how much of this can be squared with the context of the Commerce Clause, justified by precedent, or defended as misbranded products, or federalism, or anti-discrimination imperatives flowing from Article 4's Privileges and Immunities Clause are questions for another day. Today, we put Bellis Hess and Quill to rest and rightly end the paradox of condemning interstate discrimination in the national economy while promoting it ourselves. Okay, that was a little bit easier to understand. That helps me a little bit to understand why these justices voted this way. Our dormant commerce cases usually prevent states from discriminating between in-state and out-of-state firms. Normally prevent states from discriminating between in-state and out-of-state firms. Under what circumstances would a state discriminate between in-state and out-of-state firms? Maybe states would charge out-of-state firms more sales tax than an in-state firm, when they shouldn't discriminate against that. And these two cases, Bellis Hess and Quilcor, are enforcing a judicially created discrimination. Now, if perhaps Bellis Hess and Quill were legislating from the bench, then they should be overturned. Yeah, if Bellis Hess and Quill was legislation from the bench, then they should be overturned because it's not federal, or because it's not judicial, what's the word I'm looking for? Jurisdiction. It's not the federal, it's not the Supreme Court's jurisdiction to rule on those things. Now, if Congress wants to pass a law that establishes these things, I would think that would be okay. I would think that Gorsuch would be okay with that. Maybe Gorsuch thinks that this is a good thing, but he thinks that Congress should be the ones to do it. Interesting. Let's move on. Let us read as much of Roberts' dissent as possible. In Bellis Hess versus Illinois, the court held that under the Dormant Commerce Clause, a state could not require retailers without a physical presence in the state to collect taxes on the sale of goods to its residents. 25 years later, Quill versus North Dakota, this court was invited to overrule Bellis Hess, but declined to do so. Another quarter century has passed, and another state now asks us to abandon the physical presence rule. I would decline that invitation as well. I agree that Bellis Hess was wrongly decided for many of the reasons given by the court. The court argues in favor of overturning that decision because the internet's prevalence and power have changed the dynamics of the national economy. But that is the very reason I oppose discarding the physical presence rule. E-commerce has grown to a significant and vibrant part of our national economy against the backdrop of established rules, including the physical presence rule. Any alteration to these rules with the potential to disrupt the development of such a critical segment of the economy should be undertaken by Congress. The court should not act on this important question of current economic policy solely to expiate a mistake it made over 50 years ago. This court does not overturn precedents lightly. Departing from the doctrine of precedent is an exceptional action demanding special justification. The bar is even higher in fields in which Congress exercises primary authority and can, if it wishes, override this court's decision with contrary legislation. A bunch of precedent. Judicially created doctrine implementing a judicially created cause of action. In such cases, we have said that the burden borne by the party advocating the abandonment of an established precedent is greater than usual. That is so even where the error is a matter of serious concern, provided correction can be had by legislation. We have applied this heightened form of precedent in the Dormant Commerce Clause context under our Dormant Commerce Clause precedents. When Congress has not yet legislated on a matter of interstate commerce, it is the providence of the courts to formulate the rules. But because Congress has plenary power to regulate commerce among the states, it may at any time replace such judicial rules with legislation of its own. In Quill, this court emphasized that the decision to hew to the physical presence rule on precedence grounds was made easier by the fact that the underlying issue is not only one that Congress may be better qualified to resolve, but also one that Congress has the ultimate power to resolve. Even assuming we had gone astray in Bellis Hess, the very fact of Congress's superior authority in this realm gave us pause and counseled withholding our hand. We postulated that the better part of both wisdom and valor may be to respect the judgment of the other branches of the government. Scalia concurring in part and concurring in judgment, recognizing that the precedent has special force in the Dormant Commerce Clause. The court thus left it to Congress to decide whether, when, and to what extent the state may burden interstate mail order concerns with a duty to collect the used taxes. This is neither the first nor the second, but the third time this court has been asked whether a state may obligate sellers with no physical presence within its borders to collect tax on sales to residents. Whatever salience the adage third time's a charm has in daily life, it is a poor guide to the Supreme Court's decision-making. If precedent applied with special force in Quill, it should be an even greater impediment to overruling precedent now, particularly since this court in Quill tossed the ball into Congress's court for acceptance or not that a branch elects. Congress is now free to decide the circumstances with this statement. Congress has, in fact, been considering whether to alter the rule established in Bellis Hess for some time. See addendum to brief for 4 United States senators as amici curiae, brief for Representative Bob Goodlatte et al. As amici curiae. 3 bills addressing the issue are currently pending. See Marketplace Fairness Act of 2017, Remote Transactions Parity Act, and No Regulation Without Representation Act. Nothing in today's decision precludes Congress from continuing to seek legislative action, but by suddenly changing the ground rules, the court may have waylaid Congress's consideration of the issue. Armed with today's decision, state officials can be expected to redirect their attention from working with Congress on a national solution to securing new tax revenue from remote retailers. See brief for Ted Cruz et al. Overturning Quill would undo much of Congress's work to find a workable national compromise under the Commerce Clause. The court proceeds with an inexplicable sense of urgency. It asserts that the passage of time is only increasing the need to take the extraordinary step of overruling Bellis Hess and Quill. Each year, the physical presence rule becomes further removed from the economic reality and results in significant revenue losses to the state. The factual predicates for that assertion include a Government Accountability Office estimate that under the physical presence rule, states lose billions of dollars annually in state tax revenue. But evidence in the same GAO report indicates that the pendulum is swinging in the opposite direction and has been for some time. States and local governments are already able to collect approximately 80% of the tax revenue that would have been available if there were no physical presence rule. Among the top 100 internet retailers, that rate is between 87 and 96%. Some companies, including the online behemoth Amazon, now voluntarily collect and remit sales tax in every state that assesses one, even those in which they have no physical presence. To the extent the physical presence rule is harming states, the harm is apparently receding with time. The court rests its decision to overrule Bellis Hess on the present realities of the interstate marketplace. As the court puts it, allowing remote sellers to escape remitting a lawful tax is unfair and unjust. Unfair and unjust to competitors who must remit the tax, to consumers who pay the tax, and to the states that seek fair enforcement of sales tax. But the present realities of the interstate marketplace include the possibility that the marketplace itself could be affected by abandoning the physical presence rule. The court's focus on unfairness and injustice does not appear to embrace the consideration of that current public policy concern. Oh boy, this has been a lot of reading. I'm still formulating my opinion on this. Right now, my thinking is this. My thinking is that the physical presence rule should be maintained. My thinking is also that if Bellis Hess and Quill are the poor decisions that they were, then perhaps they should be overturned. Do I think they should be overturned in the manner in which they are being overturned? I'm not sure about that. I don't know that I would say that this is the way that we need to get rid of those policies. Usually, legislation from the bench is overruled by congressional action. It's not often that the Supreme Court will overrule itself for the sake of correcting bench legislation. This is an interesting case. I am much less upset now than I was reading the syllabus. And let me just say, again, I cannot wait for Justice Kennedy to retire. If Justice Kennedy retiring means we read less 40-page opinions, I will be so happy. That's going to do it for this video. I don't know how long that I've gone, but I hope that you enjoyed. I hope that you stuck around. Leave a like if you enjoyed this video. Hit subscribe and hit the bell for notifications so that you don't miss future reports. Make sure that you're checking back every weekday just in case some shenanigans are going on. Thank you again so much for watching, especially this video, especially for your patience. Thank you so much. Until next time, have a good weekend, good night, and God bless.